It's my great pleasure to welcome you here in person and online for this year's installment of our signature series, Whither the Court, the Allan C. Lebow Annual Supreme Court Review. If you are seeking MCLE credit and you're online, you'll be getting an email. If you're seeking MCLE credit and you're here in person, you should visit the table before you leave. This event, the 22nd annual edition, examines the major trends and cases of the last Supreme Court term and looks ahead to the term that just started this month. We honor UCLA Law's Allan Lebow, class of 1972. Allan was a valuable member of our community who practiced corporate and bankruptcy law before his much too early passing while a young and vibrant man. The Lebow family generously endowed this event to honor his memory, and we thank them for their commitment to UCLA Law. I'd like to extend a special thank you to Cindy Lebow for her ongoing support for this event and her contributions to the larger UCLA campus. Cindy, who is celebrating her 50th anniversary of her graduation from the law school this weekend, is deeply disappointed that health difficulties have prevented her from traveling from her home in DC to celebrate in person this year. But we know she's watching the event on our live stream. She's asked me to share these brief remarks before we begin our program. The annual Supreme Court Review Program has been one of the highlights of the UCLA calendar, taking place as it usually does at the beginning of the school year. 10 years ago, I was especially pleased with the participation of Allan's family in permanently funding and underwriting the program, ensuring its permanence as one of the most prestigious such programs offered by the various top law schools in the country. The event is aimed at an audience of students, faculty, alumni, and practitioners throughout the Los Angeles area, bringing them up to speed with the most important developments at the court. The program is aimed at assessing the most important decisions of the prior term and looking ahead to significant cases that will be heard and decided in the coming term. For those of us of a certain age, we remember Allan as an exceptional graduate of this law school who, in his all too short career, represented the very best that a lawyer could be. The events of that tragic plane crash in San Diego in September 1978 are indelible memories as we think back on the events that occurred during our legal careers. So it's fitting today, we are celebrating 10 years of the program, just as I am commemorating my 50th law school reunion. My pride in supporting the Whither the Court program cannot be adequately expressed. It has illuminated much that I've done as I have become a permanent continuing lecturer teaching constitutional law to impressionable UCLA undergraduate students over in the political science department, and occasionally as an adjunct member of this most distinguished law faculty. I can't help but think that Allan would approve. It has been my hope that we would continue to combine the expertise of our in-house constitutional scholars with new voices from outside the law school, underscoring the significance of the signature UCLA program. To that end, we have previously hosted constitutional scholars, including Lawrence Tribe and Linda Greenhouse. There are a couple of other people I must acknowledge and thank. First and foremost, I want to thank our new dean, Dean Michael Waterstone, welcome him to the law school community, and thank him for backing of Whither the Court. Dean Waterstone needs no introduction where he's to the political science department, where he's a distinguished alumnus, and I hope this program will convince him how much Whither adds to the luster of the law school. I look forward to working with you, Dean Waterstone, as we seek to inform the UCLA community as to how every day the Supreme Court impacts our lives and futures. Thank you to Rick Hassan, Latoya Baldwin-Clark, Eugene Volokh, Lauren von Schipgard, and Joey Fishkin. I want to take a moment of personal privilege to say something to my fellow UCLA Law graduates, whatever you're graduated and whatever your field of practice. I have spent 50 years either as a practicing lawyer or as a practicing policymaker, much of it either as senior staff in the US Senate, the Justice Department, or academia. These are dangerous and dysfunctional times to a degree not seen in modern US history. Our democracy is under siege and the rule of law has been challenged. As lawyers, whatever your day job, you are leaders in our community and are looked to by many people for judgment, guidance, and wisdom. You may want to retire, but you can't. We need you to stay engaged and informed to continue to provide the kind of leadership at all levels that will be so necessary in the days and months ahead. As UCLA Law graduates, you are the best of the best. As you will learn this weekend, so much more will be asked of you if our democracy is to survive and thrive. Thank you for listening. I believe we are entering into one of the most consequential periods of our lives. Those were the remarks of Cindy Lebow. This past term indeed has been one of the most consequential in many years, with important precedents set and some established precedents overturned. Here, it's appropriate that we turn to this superb panel of legal experts from the UCLA Law faculty to analyze and discuss the direction of the court. I would like to start the conversation and introduce the panel. I'll start at the far end. Eugene Volokh, class of 1992, is the Gary T. Schwartz Distinguished Professor of Law and one of the leading scholars of the First Amendment in the country. Latoya Baldwin Clark is professor of law. She writes and teaches about education law, family law, property law, race, and discrimination. Joey Fishkin is professor of law, where he teaches and writes about employment and discrimination law, election law, constitutional law, education law, fair housing law, poverty and equality, and distributive justice. Lauren Van Schipgard is class of 2012. I'm the 1991. As an assistant professor of law, her research focuses on tribal sovereignty and federal Indian law. With that long introduction, please join me in extending a warm welcome to our panelists. All right, I thought I'd open with you, Joey. This was a term that featured two very important voting rights decisions, and decisions which didn't play to the kind of normal expectation we have of, 6 conservatives, 3 liberals, the courts are going to divide. The cases are Allan versus Milligan and Moore versus Harper, 2 very different cases. Let's start with Allan versus Milligan. What did the court do? What was surprising about it?
Sure. So Allan v. Milligan was a redistricting case, a voting rights case from Alabama. To skip to the end, it's a 5-4 Roberts decision holding that basically nothing changes with respect to the Voting Rights Act, Section 2. And what that means is Alabama drew its maps in 2020. Under the Voting Rights Act, it was very clear to everyone involved that Alabama needed to draw 2 Black majority congressional districts in the state. The Voting Rights Act says that basically you have to draw your lines in such a way that every racial group has an equal opportunity to elect some candidates of their choice. And when you have extreme racially polarized voting like in Alabama, the way that plays out is that depending on the population of a group, you're going to need to end up with a number of districts where that population can elect some candidates of their choice. And in this case, it was one of these strange cases where if your model of the Supreme Court was, well, basically look at the precedents, that's what they're going to do, there would be no reason why they would have even taken this case. It was pretty clear in the lower courts that, come on, Alabama obviously needed to create a second Black district. So the interesting thing about this case is that it went up initially on the so-called shadow docket, the emergency docket, and the Supreme Court said, no, lower courts, don't make Alabama change its maps. Those maps can be in effect for the election immediately following the redistricting, and indeed those maps are in effect now. But when the actual case eventually found its way up on the merits to the Supreme Court, it was a situation where the parties all kind of wondered, how far is this court going to go in moving voting rights law in a kind of more conservative direction? And there's been a long history, of cases under the Roberts Court from Shelby County in 2013, where the court got rid of Section 5 of the Voting Rights Act, to Brnovich, where it cut back on Section 2 of the Voting Rights Act. And so I think most observers thought, especially in light of the emergency order saying keep the maps in effect, that the Supreme Court was going to say the Section 2 standard is going to be radically changed and it's going to be fine for Alabama to do what it did. Instead, in a 5-4 decision by Chief Justice Roberts, the court held that Alabama needed to follow the standard, it's a case called Jingles, that needed to basically follow the Voting Rights Act as we know it. And, I think there's a lot to be said about the substance of what happened there. The Alabama's theory of how to sort of flip around the Voting Rights Act was it should be that you only have to draw the same number of majority-minority districts that a computer program would make up if just sort of randomly drawing districts in a race-neutral way. And that would have pretty much eviscerated the protections of the Voting Rights Act, because the whole point of the act is when you have racially polarized voting and a minority group is getting consistently outvoted by white voters voting as a block, then you need to actually take account of that in a way that this computer-drawn maps idea wouldn't. And so the court acknowledged when you're drawing maps, you have to take account of race. Keep that in mind when you hear from Latoya in a moment. because the court sort of could see that obviously you can't follow the Voting Rights Act unless you take account of race. So that's the substance. I guess the bigger picture here is that when you have a Supreme Court that has moved in a significant direction, and this court has moved to the right in a significant way under the most recent series of appointments going back a few years, it creates these sort of questions and opportunities for litigants to try to throw some cases up to the court that are further to the right and see whether the court will accept those invitations. This was a case in which the state of Alabama thought it had the votes to violate the sort of current version of the Voting Rights Act, and they just went ahead and tried it. And the Supreme Court said, no, that's too much. We're not going to eviscerate the act in this way. We're going to uphold the precedent as we know it, but with the asterisk that the justices did keep the existing maps, which have only one Black majority district, in effect for the current election cycle. So we'll see what happens in this state and others in the next round of congressional elections.
So while the headline of the Allan case was the Supreme Court keeps things the same, and that's news. In Moore versus Harper, the court weighed in on something that the majority had never weighed in on, something that I have a lot of trouble explaining to people because it's so complicated, the independent state legislature theory. In 3 minutes or less, explain to us the most complicated election law case the court has heard in 20 years and tell us what its significance is.
Why, thank you, Professor Hassan. That's an excellent intro, and I'll just So, okay, this case is Moore v. Harper. It's another redistricting case. This one from North Carolina, and the reason this is complicated to explain is because there's a theory, and perhaps my previous comments have set you up to recognize this is a little bit of a related pattern. There's a theory that some of the justices on the furthest right part of the court have been sympathetic to for a while, but no court majority has actually endorsed it. And in this case, there was an effort to see if the court would actually endorse a full-throated version of this theory. So what is the theory? The independent state legislature theory is this. The Constitution has some clauses, 2 of them, that say that the times, places, and manners of choosing senators or representatives, then there's another clause about president, that this is up to state legislatures to make the rules, and then Congress can backstop those rules. Congress can override them. And so, for a couple centuries of American history, everybody has sort of assumed that when it says state legislatures, what it means is the regular state lawmaking process. State legislatures write laws, their governors sign them or veto them, the state courts review them, and that is what happened here. North Carolina engaged in a pretty sharp partisan gerrymander that their state Supreme Court said you can't do under our state constitution. Okay, so the legislators who wanted their map to go into effect went to court, to federal court, and said, wait a minute, the independent state legislature theory is this. It says in the Constitution, legislature. That should mean that we get to make the rules, not the state courts, the governor, other parts of the state lawmaking apparatus. And if this theory were accepted, the reason this case got so much attention has nothing to do with redistricting. It would mean that state legislatures would have a kind of unfettered power, unmoored, as some have suggested, the name of the case, Moore v. Harper, this sort of unbelievably broad power to just make the rules, whatever rules they want. And that raises questions. Well, could they just say, we're going to send electors to for a different presidential candidate than the one who got the votes in our state? And questions like that. So what the court said in this case, it's a little bit of a headline and kind of read the subhead. The headline is, no, we do not endorse this kind of extreme theory of the independent state legislature. When it says legislature, that means the legislature in its ordinary lawmaking role, which means, the governor has to sign the laws, the Supreme Court of the state gets to review them under the state constitution as for all other state laws. It's the normal process. It's not this sort of like the federal constitution coming in and saying, aha, legislatures only, get out of the way, everybody else. However, there was a kind of note of caution that many election law scholars were very attuned to, even if the headline was no independent state legislature theory, the subhead is, but maybe an independent state legislature theory, which is the court suggested, and there's a Kavanaugh concurrence that kind of particularly underscores this point, that maybe in the future there could be a case where a state Supreme Court was so out of left field in how they were interpreting a state law that maybe we would say that does violate the part of the Constitution that assigns to legislatures the job of making the rules. Here, the court said, well, this doesn't look like that. But imagine a Supreme Court, a state Supreme Court that was really getting out over its skis and just interpreting the state constitution in a crazy way. The federal courts would want to say you can't do that. And this led to a lot of puzzlement among scholars and observers because, of course, federal courts already can do that. If a state court says something crazy, a federal court could say, even though we defer to you about the interpretation of state law, we can't defer this much. This is crazy. So the question is, like, how much more has the court signaled that they're going to, in the future, entertain these independent state legislature-ish attacks on what state courts do? And we don't know. And I don't think the court knows. I think this is a court that's a little bit leaving its options open, and that depending what the facts are of some future challenge, which is a very pointed issue, given that in 2024, we could have, in a presidential election, fights like we had in 2020, where sometimes, that was a pandemic. And so state courts were doing a lot of changing of state law to accommodate the pandemic. And a lot of litigants were challenging that and saying, state courts can't come in and make these changes. We may have this sort of thing again, and we'll have to see then exactly how far does this court want to go in endorsing some kind of mini version of the independent state legislature theory. So sorry, that was 5 minutes.
No,
okay.
That was great. And I'm going to want to come back to you in a broader discussion when we're done with each of these deep looks at a few cases to ask, what does this say about where the court is as a court? But we'll come back to that point. I want to turn to LaToya, and if the cases that Joey talked about were the ones that went against what we expected, the affirmative action cases, one out of Harvard and one out of UNC, were kind of exactly what we expected, with the court dividing along ideological lines and striking down certain uses of affirmative action education. So what I'd like you to tell us is, what is the significance of this decision, and what exactly is the holding? That's pretty significant, especially here in California, where we have Prop 209s. Like, does this even matter here?
Thank you. So let me kind of give a background on the case and then come to the questions that Rick has asked. So in late November 2014, Students for Fair Admissions, SFFA, filed suit in 2 federal district courts against Harvard and also UNC over their use of race in university admissions. SFFA is a membership organization headed by Edward Bloom, who is a political operative who spearheaded previous anti-affirmative actions cases in front of the courts and contributed to the attack on the Voting Rights Act in the 2010s. Of course, this just... Can you come back to me in a moment?
Mm-hmm. Sure.
Because my notes here have kind of disappeared.
That's fine. We will come back to you, and I'm going to you pull those up, and I'm going to turn to Eugene next. And Eugene, you are one of the country's leading First Amendment scholars. We often think of First Amendment as focused primarily on speech, but it also is focused on issues of religion. Sometimes there are conflicts between constitutional rights. Sometimes there are conflicts between anti-discrimination laws and people's interest in practicing their religion or even expressing their views. This issue came up most recently in the Supreme Court in a case called 303 Creative. I think that there was so much going on at the end of the term. I think this didn't get as much attention as some of the other cases, but people in the field think that it's quite significant. So could you just kind of first set the stage for us, tell us what was at issue in the case, and why was this a new ground for the court?
Sure. So let me just step back a bit and say a little bit about the First Amendment, a little bit about anti-discrimination law generally, and then about what the court decided here. So first, the First Amendment provides protection for religion and religious practice. The scope of that is controversial. Turns out that this case did stem from religious beliefs of the challenger. It was a free speech case. Like many, there are lots of such important free speech cases. The flag salute case from the 1940s, for example, stemmed very much from the religious views of the Jehovah's Witnesses who opposed the flag salute, but the court struck it down as a free speech matter, so independently of the religion claim. But when it comes to free speech, the court has recognized that it protects the right to speak, it protects the right to create expression, it protects the right not to speak. So, for example, you're entitled not to say the Pledge of Allegiance. You're entitled not to have a state-provided motto on your license plate. So then the question is, what about this fourth box? What about a right not to create expression? And interestingly, the Supreme Court had never really confronted that question. So that's the free speech and the First Amendment, a big picture. The anti-discrimination law, big picture, when it comes to the First Amendment, is that anti-discrimination laws, state and federal, whether employment, education, public accommodations, are subject, like any other law, to First Amendment constraints. That doesn't mean by any means they're always invalid, just like national security measures are usually perfectly valid, but sometimes they are struck down on First Amendment grounds. So to give a few examples, well, first let me start with examples of First Amendment challenges to anti-discrimination laws that have failed. So for instance, some private clubs have said, private organizations like it was the JC's case in the 1980s, have said, look, we have a right to exclude women because we want to have a club that's for men, either for men to associate with each other for personal purposes or for expressive purposes. And the Supreme Court said, well, no, at least unless you can show that allowing women into the club will somehow substantially change your message, you don't get an exemption from anti-discrimination law. There's another case from the mid-1970s which involved schools that were set up essentially for segregation purposes, private schools that excluded Black students. And in a case called Runyon v. McCrary, the court said, well, of course, if those schools want to teach segregation and teach racism, they're free to do that. They have the First Amendment right to do that, but they don't have the right to exclude students based on race. So you have a right not to speak, right to speak, but you don't have a right to exclude particular students. On the other hand, returning for a moment to the religion clauses, I hear there are some religious groups that discriminate in their choice of clergy and have been doing this for thousands of years. Some do it based on sex, famously. Some do it based on race. Some do it based on ethnicity. Some may do it based for other bases, marital status. Many state employment laws ban discrimination. Marital status, famously, Catholic Church, generally speaking, requires priests to be male and unmarried. But the court unanimously said, well, of course, these institutions have a First Amendment right to say no. As to at least our clergy and to teachers of religion, where the line is drawn there is actually a matter that's more contested. There is a First Amendment right to exclude. Likewise, there was a case involving a gay rights parade, St. Patrick's Day parade in Boston, and a pro-gay rights organization wanted to march. The organizers said, no, this is not what we associate with real good Irishness. State court said, no, this parade is a place of public accommodation that cannot discriminate based on sexual orientation. Supreme Court unanimously said, well, that's unconstitutional because the parade has a right not to speak. That is to say, the organizers of the parade, who are like choreographers that organize various floats, various marchers into one coherent-ish whole, are entitled to say, we don't want to have this particular group. Likewise, more controversially, this was a 5-4 case, the Boy Scouts were held to have a First Amendment right not to allow essentially gay assistant scoutmasters. Assistant scoutmasters speak behalf of the group. The group said it had a commitment to traditional sexual mores, which included heterosexuality, and that therefore they were entitled, and the court agreed, to exclude people based on sexual orientation. So what happens in 303 Creative? 303 Creative is a web design company that's run by one particular person, basically, and they have she's Christian, she has particular set of moral views, and she says, we're not going to design certain kinds of websites, including websites for same-sex weddings. We're fine. We have no objection. If you're gay and you want to put up a website for something else, we're happy to do that. We don't actually care so much about your identity. What we do care about is the message that the website contains. And we have a right not to create it. So this, of course, has most prominently come up in the context of sexual orientation and same-sex weddings, but the same issue could arise in other contexts as well. So, for example, you could imagine a freelance writer, assuming state law treats the freelance writer like the freelance web designer as a place of public accommodation, who is asked to write a press release for the Catholic Church or for the Scientologists, let's say. And he says, no, I don't approve of their views. I don't want to put pen to paper. There's a dated metaphor for you, figurative usage for you. So I don't want to put pen to paper to write things that I don't approve of. It's true they won't come out under my name. It's going to be under the name of the organization. Still, I'm being asked to create things I don't want to create. Or some jurisdictions ban discrimination based on political ideology. Seattle is an example of that. So let's say somebody says, I want you to, you're a graphic designer, you're open to the public, I want you to create a pro-Palestinian graphic. Or I want you to create a pro-Israeli graphic. And the graphic designer says, no, I do not want to create that. That is inconsistent with my, not even religious beliefs, just my moral beliefs. So the question is, should those organizations, should those people be allowed to say, we refuse to create this website because we don't approve of this content, or create this speech, excuse me, more broadly, because we don't approve of its content, even when their decision is based on the sexual orientation of kind of the event that the speech corresponds to, or the political ideology, or the religion, or for that matter, sex or race or whatever else that is connected to the content of the speech. And the Supreme Court, in Theory 3 Creative, by 6-3 votes, sort of the usual conservative liberal split these days, said, yes, they do have a right to refuse to create that. Anti-discrimination laws remain facially valid. They remain applicable to a vast range of behavior, but not to situations where applying them would coerce someone into creating a speech product that they disapprove. That is part of the First Amendment right not to speak, is the right not to create speech, just like you have a right, again, not to say things like the Pledge of Allegiance, or display things on your car like the state motto. So you have a right not to create. The dissenters said, well, wait a minute, this is a generally applicable law. It's content neutral. The law itself just bans discrimination and public accommodation on certain bases. That is, that's a content neutral, even speech neutral law. And people shouldn't be able to get exemptions from such, at least generally shouldn't be able to get exemptions from such generally applicable laws, especially with anti-discrimination laws, just because what they want their exemption for is for their First Amendment purposes. And the majority disagreed. The majority said that in fact, in their view, that indeed people cannot be coerced through the threat, of course, of civil liability, but that has long been understood as coercion, cannot be coerced into creating, including as part of their business, creating messages that they disapprove of. And that is true even when the coercion operates through content neutral anti-discrimination. So it's a kind of a narrow decision on its own. It only applies to the creation of speech. So it wouldn't apply to the limo driver who doesn't want to drive to a same-sex wedding. Wouldn't apply to a hotel that doesn't want to host the same-sex wedding. Wouldn't apply to caterers. Interesting question. Would apply to florists. Is that a speech product or not? I mean, we say it with flowers. There's a symbolic component. Of course, there was a famously debate about this with regard to custom-made wedding cakes. So there are actually some borderline cases. But it's pretty clear it would cover also photographers, videographers, calligraphers, wedding singers, all examples of things that have come up in other such cases before. Pretty clearly wouldn't cover limo drivers, hotels, caterers, and the like. Then there's going to be some dispute about what happens in between.
Before I turn back to Latoya, let me just ask you very briefly, why didn't the court consider this as a free exercise of religion case? Why was this a speech case?
Well, so it was litigated fundamentally as a free speech and free exercise case. The court agreed to hear the free speech side. And this is partly because there's actually a hot debate on the court about what the scope is of the free exercise clause. Some justices think that it gives people a right to exemption from generally applicable laws, not just as to speech, but as to lots of other things. Perhaps drug laws, anti-discrimination laws, people have made claims about tax laws, exemption from tax laws, although courts have generally rejected those. So some say there's a right to this exemption. Others say there is no right to exemption. And others say, well, we think there should be a right to exemption, but it's not clear exactly what the rules should be. So that's something that's divided the court already. I think the court may have wanted to kind of avoid that issue. Here's the other important factor, though. Free exercise claims, rightly or wrongly, say religious objectors get special benefits that others don't. In fact, one argument against a broad view of the free exercise clause is it gives religious objectors this privileged position that they shouldn't have, although defenders of the broad vision say, well, that's what the Constitution says. Free speech claims are enjoyed by everyone. I mean, there are relatively few, I think, secular people who object to same-sex weddings, but some might. And they certainly may be secular people who may object to having to create religious messages they disapprove of or political messages and the like. So by making it a free speech claim, the court stressed this isn't just about the special rights of religious people, it's about the rights of all speakers.
I meant to say at the beginning that there are index cards at your table, and if you would like to write a question, I'll try and get to some of those at the end of this program, and the staff will come around and collect those.
So pen to paper isn't as obsolete as we thought.
I think if you're online, you're using the Q&A box, but at least here in the real world. All right, so let's come back to LaToya.
Back to me. Thank you so much. I have a kid that used up all the ink in my printer this morning, and so I'm relying on technology. So like I said, SFFA filed this suit in 2014 against Harvard and against UNC for their use of race in their admissions programs. They argued that the programs violated both the Equal Protection Clause of the 14th Amendment, as well as Title VI, which applies to all education programs that accept federal funds for education, which will include private universities and colleges as well. So both cases held trials in their respective district courts, and the district courts filed or found for the universities in both cases. Both courts were very long opinions, statements of fact, and also conclusions of law. There were over 130 pages in one case and 150 pages in the next. And both courts found that the respective plans actually satisfied strict scrutiny, which you remember requires a compelling government interest and then a narrow tailoring of the means to actually achieve that compelling interest. And that they ruled that these admission programs actually complied with the court's prior jurisprudence on affirmative action, which allowed diversity as a compelling interest and a limited use of race as part of a holistic review that is narrowly tailored to that interest. As we now know, the court's majority, which included Chief Justice Roberts, wrote the opinion together with Justice Thomas, Alito, Gorsuch, Kavanaugh, and Justice Barrett, and they found that Harvard and UNC's use of race was actually unconstitutional and used that same analysis to find that the programs violated Title VI. Justice Sotomayor dissented with Justice Jackson not voting, and I will put in a pitch for Justice Sotomayor's dissent because I was cited in that dissent.
Ah, nice.
Yes. So the court's opinion starts with a discussion of its reading of history of the Equal Protection Clause. It particularly draws on Brown versus Board of Education. Its seminal 1954 case that declared racial separatism in public schools denied Black children equal protection under the law. Brown held that the states, if they chose to provide education in the first instance, must do so on terms that are equal to all. The opinion actually quotes, the SSFA opinion, quotes briefs that were submitted in Brown to show that the Brown plaintiffs themselves wanted, quote, no state to have any authority under the Equal Protection Clause to use race as a factor in affording educational opportunities among its citizens. Now, of course, those briefs were submitted in a context of education not being denied to white children on the basis of race, but to Black children on the basis of race. And Justice Marshall, who was the legal architect of Brown, actually vigorously supported race consciousness. Nevertheless, the SSFA opinion concluded that the core purpose of the Equal Protection Clause is to do away with all governmentally imposed discrimination on the basis of race. And so accordingly, the court says, quote, any exception to the Constitution's demand for equal protection must survive a daunting two-step examination, which we know to be strict scrutiny. One interesting thing I found is that unlike the previous cases, the court here positions affirmative action itself as an exception to equal protection. And for such exceptions to survive, the court says, race can only be used in the most extraordinary of cases. Now the court, in the opinion, goes through to explain how their previous jurisprudence actually leads to the answer that they conclude in SSFA. There's 3 generations of affirmative action cases that are implicated here. So the first is Bakke versus Regents of California, which was decided in 1978, but by a very fractured court. A decision that was penned by Justice Powell, which was actually joined by no other person on the court, provided the deciding vote, however. And over time, his opinion became the basis for the only compelling interest outside of remediating specific instances of intentional discrimination that the court recognizes for university admissions, which is diversity. So since 1978, the last 45 years, diversity has been held as a compelling interest that can justify affirmative action programs. While the Bakke court did invalidate quotas, it did allow for holistic review, where an applicant is considered as a whole person, and the courts then found that that was narrowly tailored enough to satisfy strict scrutiny. The court upheld diversity as a compelling interest in holistic review with a limited use of race as narrowly tailored in 2003 in the cases that came out of the University of Michigan, Grutter and Gratz v. Bollinger, which upheld in part that the University of Michigan's law schools limited use of race in their admissions process. What Grutter, the law school case, added to Bakke, which the court heavily relied on in SSFA, was this idea of a time limit. So in Grutter, the law school case, Justice O'Connor wrote, quote, that we expect 25 years from now, the use of racial preferences will no longer be necessary to further the interest improved today of diversity. Now, to many, that 25-year language was dicta, right? Not a core holding of the actual case. And the number itself might have been less significant than first thought. Even Justice O'Connor several years later said, oh, 25 years may have been a miscalculation. Also, in 2014's Fisher 2, the court again affirmed the limited use of race in college admissions was a compelling government interest that could be narrowly tailored and survive strict scrutiny. But here, the court rejected the diversity arguments that were made by Harvard and by UNC. Harvard argued for diversity-related benefits of a racially diverse class, including, quote, preparing graduates to adapt to an increasingly pluralistic society, and, quote, producing new knowledge that stems from diverse outlooks. UNC also argued for diversity-related benefits that would, quote, promote the robust exchange of ideas, enhance appreciation, respect, and empathy across racial understandings, and breaking down stereotypes. The court, though, rejected these interests because, they said, these were commendable goals. They were not sufficiently coherent to be compelling. Interestingly, one of the court's rationales was that these goals were too challenging to actually measure, although it accepted very similar goals in the past. Furthermore, the court argued that this limited use of race was actually no longer narrowly tailored. To do so, and what's very interesting to me, is that in part they attacked the notion of racial categories themselves as incoherent and imprecise. So it noted that many of the categories that are used by schools, Asian, Native Hawaiian, and Pacific Islander, Hispanic, white, African American, and Native American, were impermissible means of achieving diversity because they are imprecise and over and under inclusive. Now, of course, the federal government uses these very same categories all the time, including, most importantly, in the census. So it seems as though the federal government does recognize there is some coherence to these categories, even if the court now says there are not. More substantively, and again, something that I'm very interested in, and it goes thinking about what Joey was talking about, is that the court really put forth a theory of what race actually is. So it held that affirmative action plans like that in Harvard and UNC failed because they grouped people who may have little in common with one another than the basis of the color of their skin, which is equating race with something so irrelevant as skin color. It also quoted a case that invalidated a voting regime in Hawaii that set aside seats on a particular council only for Native Hawaiians and Hawaiians, those definitions themselves being derived from the history of Hawaii. In that case, the court said that race was an impermissible classification because, quote, it demeans the dignity and worth of a person to be judged by ancestry instead of by his or her own merit and essential qualities. This visual seems to say that race has no relevance beyond, let's say, the Crayola color that you would choose to color yourself in, or whatever your ancestry is as created on something like 23andMe. And also as an aside, from my perspective, it's very interesting, this argument about being demeaning, in that Black people in general have not found affirmative action to be demeaning at all. In an April 2023 poll, over 68% of Black Americans strongly supported affirmative action. Going to Rick's question though, what appears on the very last pages of the opinion and maybe a couple of paragraphs, one suggests that the court knows that race is actually more than skin color or direct ancestry. The court does not say that universities and colleges may never consider race. What it says, though, is that an applicant can write in their essay about how race has affected his or her life, quote, be it through discrimination, inspiration, or otherwise. It does say that those experiences must be individual experiences, but of course that colleges and universities can actually still consider it. And so it understands that race is not just color or ancestry. Otherwise, when would it ever be relevant to write about race? It must acknowledge then that race is far more if it is to have any meaning in an applicant's life. And if we think about the voting rights cases, the court is very clear that there's something about Blackness that is not just about skin color, right? The court also said that it doesn't preclude race-neutral means of increasing racial diversity as long as those means themselves are not race-conscious. And it's also not invalidated other programs such as equity, diversity, and inclusion. Now, one thing I think to notice is that while SSFA purposely chose Asian American applicants as opponents to affirmative action, the case actually does very little to address racial discrimination against Asian American applicants. And I really thank my colleague Jerry Kang for bringing this up and really having me think about this. So one concern that was heard a lot about in the media were these questions of personal ratings that Harvard was assigning to each of its applicants and finding that Asian Americans typically got lower personal ratings than white applicants. Now, of course, that has nothing to do with affirmative action that has now been invalidated, right? One is that it's somewhat unlikely, although we can't say for sure, that admissions committees were intentionally giving Asian American applicants lower ratings in order to intentionally discriminate, but probably that processes like implicit bias are working in these personal rating assessments. Again, not something that this decision did anything about. And on top of that, Asian Americans are actually far less likely to be legacy students or athletes, pluses that disproportionately benefit white applicants over Asian applicants. Again, the court did nothing about that type of discrimination. And so if we were truly interested about ending racial discrimination against Asian Americans, those are the actual processes that need to be changed. So let me finish by saying a little bit about what I think this means for K through 12 education, which is really where I focus my work. So Justice Sotomayor wrote forcefully about the racial landscape of K through 12 education and how competition based on quote unquote merit is stacked against Black and Brown children. The idea being that, in my perspective, that universities need to seriously rethink what merit means in the context of a system of gross inequality, of gross inequity, and also these processes of subordination. The tight correlation between racial segregation and class segregation makes it such that most of our ways that we go about funding our public schools leave children of color with far fewer resources in their schools to be able to compete on quote unquote race neutral notions of merit. So I think what colleges and universities can do is to really implement some very strong pipeline programs that start with children, even in elementary school, to make them prepared in order to compete when it comes to selective college admissions. They should also be on the front lines fighting many of these draconian laws that are restricting books in schools. When we know that classroom curriculum and representation in books and thinking about history also has very strong academic benefits for children who do not always see themselves in the curriculum and for whom the race for college admissions is already stacked against them. So that's my time. I'd be very interested in continuing having this conversation.
Thank you. Before we open up to a general conversation, we're going to turn to Lauren and talk about tribal rights. This is an area in the court that the court's been very active in the last few years. I want to talk about two clusters of cases. The first is the case that was the challenge to the Indian Child Welfare Act, the Brackeen case. A lot of people had different expectations about how this was going to come out. What did the court do, and why is this so significant?
So the Allan versus Brackeen case was huge. It was such a big deal in Indian country. As an aside, Indian country is a legal term of art. It's defined in the Title 25 to connote the tribal lands on which tribes enjoy jurisdiction, but euphemistically, we use it to refer to Native America. And Indian country was deeply concerned about the Brackeen case. The Indian Child Welfare Act is a statute passed in 1978 intended to address wild disproportionality in the rates that Native children were being removed from their homes. Sorry. Yes, where? Put on my lap. Awesome. There were some findings that in states like Minnesota, Native children were being removed upwards of 30 to 45% of all Native children. They represented over 75% of all children in child welfare in Minnesota. So really, really damaging disproportionality rates. Congress responded with the Indian Child Welfare Act, which is not a remedial statute. It's not intended to make reparations or restore harm, but rather is a forward-looking statute, inserting procedural requirements, federal minimum standards within state court proceedings regarding Indian children. The statute defines Indian children as members of federally recognized tribes or eligible for enrollment, which is how federal Indian law generally escapes equal protection concerns, particularly racial discrimination, defining Indianness as not just racial, but also a political designation. The Indian Child Welfare Act has numerous different provisions. Some of those are child welfare policy oriented, requiring the state to provide active efforts before it, sorry, I'm getting, I think, weird feedback. I'll hold it. Requiring states to provide active efforts to encourage the reunification of children removed from the home with their parents or guardians, requiring the higher evidentiary standard for the termination of parental rights, requiring placement preferences should the child need to be permanently removed from the home and placed elsewhere that prioritizes kinship placements, placements within the tribe, and even placements with other Native American families before the child is placed with non-Native families. The constitutionality of ICWA has been challenged ever since it was enacted in 1978, but those challenges rarely ever got beyond the district court. The Brackeen case was a fundamental shift in that history. For the first time, a district court entertained that not only were certain provisions of ICWA unconstitutional, but that the entire statute was unconstitutional, and that it was unconstitutional for upwards of 5 different reasons. This goes to the Fifth Circuit. It's a complicated mess there that includes an en banc decision that was over 300 pages and really confusing about what they actually held. This tees up to the Supreme Court. Indian country has experienced a pretty varied record at the Supreme Court. Generally speaking, tribal issues do not have a welcome reception, in part because many of the justices don't have a formal background in federal Indian law, or at least that's part of the thinking. And so as part of the litigation strategy, tribes, which are generally distinct sovereigns, they are distinct from each other, and because of that, there's not really a whole lot of unification that goes around in advocacy. That was different in Brackeen. Of the 574 federally recognized tribes, I believe 550-ish all joined together in an amicus brief supporting the constitutionality of ICWA, which is kind of a big deal. The ones that didn't join tended to be relatively remote Alaska Native villages. So what happened in the case? We were expecting the worst, in part because these arguments were being entertained. This would have massive consequences, not only for the application of the Indian Child Welfare Act, but depending on the reasoning of the court, it could impact huge other areas of federal Indian law. But the court upheld it in a 7-2 decision authored by Justice Barrett, which itself was a surprise. The court really swatted away a lot of these constitutional arguments. And because of that, this decision is really celebrated in Indian country. Fundamentally, the court upheld that Congress has Article 1 plenary power over Indian affairs. And so any arguments that Congress lacked a power to enact a statute like ICWA was rejected. And it said, no, Congress not only has some power in Indian law, they have a lot of power in Indian law. And this is to the exclusion of the states. They identified 4 sources for Congress's power, including the Indian Commerce Clause, sort of the portion of the Commerce Clause pertaining to Indians not taxed, the Treaty Clause, the trust relationship between the United States and tribes, as well as the general constitutional framework that recognizes tribes as distinct sovereigns in relation to the United States. There were non-delegation arguments that states were making to say that Congress, even if it had Article 1 power, couldn't delegate some of its power to tribes. That was thrown out understanding. There were anti-commandeering arguments. Those were rejected, including particular provisions of ICWA that the court upheld. There were also equal protection arguments. Those equal protection arguments were dismissed also understanding. And so that, I think, is the one portion of the case that has Indian country still concerned, that especially in light of the affirmative action case, that this may return.
All right, very briefly, before we open it up, it wasn't all good news from the point of view of the tribes last year. And what can you tell us about some of the other cases, including the Arizona versus Navajo Nation case and the, I'm going to pronounce this wrong.
Lac de Flambeau.
Thank you. Yes.
Okay, so very quickly, this, which is ironic because this was a water law case, which is famously very complicated. Essentially, the Navajo Nation, a tribe located in Arizona, Utah, and New Mexico, the largest tribe in the country, 300,000 tribal members, and a reservation that is equivalent to the size of West Virginia. Under water law, if you remember, like prior appropriation, first in time, gets all the water. All of that water law doesn't apply in Indian country. Instead, there's a doctrine known as the Winters Doctrine that states tribes have water rights sufficient to fulfill the purpose for the creation of the reservation. In the case of the Navajo, they have a treaty negotiated with the United States in 1868. Historically, there was a lot of discussion about what led to this treaty. For the Navajo Nation, they had just freed themselves from what they term as the Long Walk, their forcible relocation to an area known as the Bosque Redondo. Notably, Bosque Redondo was horrific. A lot of Navajos died there, in part because there was insufficient water. It was an arid area and the water had high alkaline. And so part of the negotiation for returning to their ancestral homelands was to form a reservation in which they would be able to make a, quote, permanent homeland. Fast forward to the 1950s, all of the litigation around the Colorado River that includes the state of California. The Navajo Nation attempts, beginning in 1956, to insert itself into what would become the water settlement negotiations. They are time and again excluded from those negotiations. And so over the decades are attempting to exercise their rights. Part of their ask was to adjudicate what their water rights were under the Winters Doctrine. In order to do this, they needed the United States as the trustee in the federal tribal trust relationship to assess what those water rights are. The United States refused, and so it led to this case. In this case, Justice Kavanaugh, writing for the majority, held that while there is a trust relationship between the United States and tribes, that does not include an affirmative duty to enforce those rights, including to assess the water rights. And so the tribe was left seemingly with no remedy.
Thank you for that. All right, so I want to turn from the specifics to a conversation about broader themes. So one thing as I'm listening to this is this is not an easy court to peg, right? There's some cases where the court plays to type. You think of the affirmative action case, or you think last term to Dobbs, where you get these Dobbs, the abortion decision from last term. You get these huge divisions along party and ideological lines. And I should say this is the first time in modern Supreme Court history where all the conservatives on the court were appointed by one a president of one political party, all the liberals by another. So the language that the people talk about on the court is much more partisan than just ideological. So on the one hand, it's a big partisan split, the Republican Supreme Court versus the Democratic dissenters. On the other hand, you get some surprise decisions that don't fit into this category. You get these, you think about the voting rights case, the Allan case or the Moore case where the court pulled back from the precipice, or you think about Burkine. These are all cases where the court still has the potential to surprise. You can still get cross-ideological agreement. And yet, if you look at the polling of the Supreme Court, it's at its lowest in modern history. There's a lot of dissatisfaction with the court. So how do we assess what's going on with the court? And, how do we read the court today? And Joey, since it's been like an hour since we've heard from you, let's start with you.
Okay.
How do you assess the current Supreme Court, and how should we be thinking about the court today? You've written a recent book with my former professor, former UCLA professor Willie Forbath, thinking about how to reconstruct the Constitution. The court's very far from that. Where do you see the court today?
Sure. I mean, I think there are still some Supreme Court opinions that surprise in the sense that there's a complicated cross coalition with liberal and conservative justices on both sides of the case, okay? But then there are quite a few cases that surprise in the sense that they don't come out the sort of 6-3 conservative way one might expect just from counting heads. But the reason for that is because, as in the two voting rights cases that I discussed, a court is being offered an opportunity to go very far to the right and is declining that opportunity. And so you have all of the 3 more liberal justices who are appointed by Democratic presidents and some of the conservative justices saying, let's keep the status quo over a dissent from the further right justices. So structurally, I think what you have here is a court that has moved a considerable distance to the right, even from the Rehnquist court, which was the most conservative court in a long time. And now the court is more in the position that the Supreme Court was 100 years ago. This is not unprecedented in American history at all, to have a very conservative court in comparison to where the general political branches are. That's where I think we are. I think what that results in structurally is kind of the inverse of something you had in the 1960s in the Warren Court era, only a little more so now, actually, which is you have both litigants and judges at lower courts who are sometimes looking at precedent and saying, you know, I have a claim that shouldn't win under the precedents, but I think this court might want to change the precedent. And the court has often explicitly signaled that they might be interested in moving where the law is. And so you have these various flyers put up, various sort of efforts to see if the court would like to press further to the right on one issue or another. And sometimes they say yes, as in the affirmative action cases, having signaled for so many years that they wanted to strike down affirmative action. And sometimes they say, okay, no, that's a little bit too far, as they did in both of the voting rights cases that I discussed. I think a product of this current situation is that it empowers kind of conservative impact litigation groups like Ed Bloom's group that LaToya mentioned. Also the Alliance Defending Freedom, which is at the center of the 303 Creative, because groups like this may say, well, you know, we want to find lots of different plaintiffs and kind of build a strategy and build a jurisprudence and see if the Supreme Court will accept our invitation. And this leads to an oddity. I mean, one kind of strange wrinkle of the 303 Creative case and its related cases, all the ones that were brought by this Alliance Defending Freedom group, which wants to increase religious and or speech, but really mostly religious exemptions from anti-discrimination law, is, you know, you had these various cases, including this website designer, but also a bunch of wedding vendors in state courts and other cases that, according to, there was a great journalistic investigation by the Washington Post a couple months ago that this sort of like dug into all of these different cases and found almost none of these people are actually in the business of doing wedding work, you know, including in the 303 Creative case. This website designer was not actually, no gay couple asked
she
her.
might.
Right. She might in the future. Some of these wedding photographers, you know, had never actually photographed a wedding, but ADF lawyers had filed their incorporation papers to make them look like a photographer, or they claimed they might want to photograph a wedding someday. And the effect of this, I think, is a problem, which is it allows the court to not only pick which controversies, but also to kind of make up or allow impact litigators to make up controversies and to take those. So that seems a problem to me, but I think it's a sort of product of the structural situation we have, which is that, you know, the political system is in one place, the Supreme Court is a bit to the right of it, and so there are various litigators and judges who want to sort of test how far that is.
Let me turn to LaToya next and ask you the same kind of question, but in the context of, you know, as far right as we might say the court went in the affirmative action cases, they didn't go as far as they could have. And one of the questions that some of the audience submitted was about the military exception to affirmative action. Of course, oh, we're not saying anything about the military. So first, could you talk a little bit about what the court said about that, but more broadly, what does this say about, you know, I kind of think of like, the question is how fast they want to push on the accelerator, and Roberts is saying slow down, and you know, Alito is saying step on the gas. Like, you know, how do you see the dynamics on the court?
Yeah, I think that's really interesting. And so, yes, the court said, we're not saying anything about military academies. I don't know that I think that they give a very, I would say, persuasive reason for why we would accept military academies, which are colleges and universities, just like Harvard or UNC, but say we can use race there, but we can't use race here. Another thing that they said that people picked up on is that you can also use it in prisons. Right? If we're trying to stop prison race riots, then it's okay to use race to actually separate people. And so these are two kind of very interesting types of exceptions to what it is that they're saying we can use race for, we can't use race for. And for me, again, this goes back to this idea of what do they even mean by race? And they seem to be using it in very different ways in very different circumstances. And so again, this goes to the Voting Rights Act. One thing to notice is that all these cases are working together, even in Brackeen, to really figure out this kind of jurisprudence of race in all of these different areas in a way that I think the Supreme Court itself believes it's being consistent, but those things all coming together are actually quite incoherent. What was the second part of your question? Or was that it?
I think that was it.
Okay,
Yeah.
cool.
So Eugene, you clerked for Justice O'Connor at the time when I think she was probably the most important swing justice on the court. People would write their briefs to Justice O'Connor. I remember after she retired, my former boss, Erwin Chemerinsky, said, he always had a picture of Justice Kennedy on his desk when he was writing a brief. It's not like that anymore. So much is more up for grabs. How do you assess the current Supreme Court? And also, what do you think about the declining popular support for the court's decisions?
Well, so I think it's worth thinking back to before I was born, or at least mostly before I was born, but it's still very much in our memories, the Warren Court, right? So the Warren Court was considerably further left under then understood senses of what left meant than pretty much any court had been probably throughout American history. It was probably in many respects, although not all respects, considerably further left of the public. As a result, there was certainly a lot of public opinion against the court. Also, if you look at the nature of the left on the court, it was actually kind of a mixed bag, right? And it varied some from topic to topic, but there were some who were really very hardcore on the left, and there were others who were maybe you might think of as more center-left. Interestingly, Justice White, who was a Kennedy appointee, became later in the Burger Court and Rehnquist Court especially, kind of a centrist justice. So there were different subdivisions here. I think we're seeing something similar today, that you've got a court that is considerably to the right of certainly the Warren Court, somewhat to the right of the Rehnquist Court as well, and the Burger Court before, which was actually more a centrist one because of the personnel on the court at the time. You also have one that some of the opinions, as I understand it, as best we can tell from the polls, are actually pretty popular. The affirmative action cases are roughly where the country as a whole tends to be, although, of course, there are subdivisions by race if you look at the polls and by other things. I don't think that the hostility to the court stems from that. Likewise, if you look at the gun rights cases, I think there tends to be pretty broad support for an individual right to keep and bear arms on the court, although it's possible as to certain kinds of cases coming up that maybe the court will go further than where the public is.
And I'm going to ask you about that in a few
Right.
minutes.
If you look at 303 Creative, as best we could tell, it's very hard to know because, among other things, it's not a subject that most people have thought really hard about. So the responses may be very sensitive to subtle differences in wording or what's in the news at the time. But it seems to be that the country is sort of half and half that way. On the abortion cases, generally, the court is more conservative than at least the polls are in the country as a whole. So it varies. And the last thing is, like the Warren Court, it's somewhat split, although here the splits are somewhat more precise. So you've got the kind of probably the more conservative justices, the ones more likely to take kind of an originalist view, the more likely on various issues to be conservative, Gorsuch and Thomas, and setting aside the originalism point, which doesn't appeal to him much, Alito. Then you have justices who are, and they're also ones who are more likely to overturn precedent. just like on the Warren Court overturned a lot of precedents, but not all the precedents, and some justices were more reluctant to do that than others. Then you have a different group also of conservatives, but Roberts, Kavanaugh, and Barrett, who you'll often see a 6-3 decision. If you see a 6-3 decision, which is not in the conservative side, that's often because it's the three liberals plus Roberts, Kavanaugh, and Barrett. So you see that, and then occasionally you see things come out differently. Like, for example, Gorsuch sometimes departs, especially as I understand in Indian law cases, departs from his conservative colleagues. Sometimes Alito and Barrett might switch sides and the like. But this is something that's pretty familiar if you look at the kind of the big picture of Supreme Court history.
So Lauren, when you were giving your description of Brackeen, you said Justice Barrett, somewhat surprisingly, and I'm wondering if that's because she didn't have a necessary background or expertise the way someone like Justice Gorsuch has, or it was because of the views she took in the case. But it seems like, at least in the tribal rights cases, Justice Gorsuch, at least, is not where you would see him. So in the affirmative action case, Gorsuch is with the majority. In the voting rights cases, Justice Gorsuch is voting with Justice Thomas, even saying that the Voting Rights Act doesn't even apply to redistricting. And Gorsuch dissents in Moore versus Harper. So he's taking these kind of very extreme positions on voting rights and affirmative action that, you know, I think we would say is more to the right if we were putting it on, but not in these other cases. Is that expertise? What explains that? And are lawyers in Indian country writing their briefs for Justice Gorsuch the way people used to write their briefs for O'Connor?
I think as a starting premise, Indian law tends to not necessarily be political, and so, or at least partisan. And so you don't necessarily see the natural divide anyways. But it's also, I don't think you can overstate how amazing Justice Gorsuch has been on tribal issues. I just don't think there's ever that Indian country has ever had an advocate like Justice Gorsuch on the court ever. And part of it is that he's coming from the 10th Circuit. And so he has seen a lot of Indian law cases in a way that the other justices didn't.
And that's Colorado and Utah.
Yeah, the mountain
Yes.
time zone. With Justice Barrett, we just didn't know. She had no record whatsoever on Indian law. And so we could only speculate. And so it was like, well, hedging our bets, and it might not be great. She's actually authored 2 Indian law opinions so far, Brackeen and the Dinespi case regarding CFR courts. And so far she seems persuadable. Justice Kavanaugh is also in this group of like, he might come on one end, he might come on the other. He authored the Arizona versus Navajo Nation case. He also included in his concurrence supporting the Brackeen holding a invitation for an equal protection challenge. So not super great. So it's a little bit of a mixed bag. Justice Thomas has historically been extremely hostile to Indian rights and remains so. But even Justice Alito will join him once in a while, but sometimes he's frequently flying on his own, arguing that there is no such thing as tribal sovereignty. There is no trust responsibility, really, really aggressive arguments. But to your question, are Indian law attorneys writing to Justice Gorsuch? No. We got his book. So we're writing to Justice Barrett and Justice Kavanaugh.
It's interesting you mentioned the concurrence of Justice Kavanaugh in one of these cases. Kavanaugh writes very important concurrences in both of the election law cases that Joey talked about. In the voting rights case, he said, well, maybe there is a constitutional argument against Section 2 of the Voting Rights Act. These seem to be invitations for future litigation. And in Moore versus Harper, he says, let's go back to Bush versus Gore. That was a great time, which was, you know, he kind of went out of his way to say that and to try to endorse the opinion of the concurrence in Bush versus Gore, the Rehnquist concurrence. So he's definitely very active in trying to send signals as to where he is. Before I turn to a couple of the cases that the court is hearing in the new term that just started the first Monday in October, I want to talk about the ethics issues at the Supreme Court, because one of the things I think may be affecting the court's popularity or lack thereof is a lot of reporting, much of it by ProPublica, some of it in other news outlets suggesting that, or reporting, I should say, that Justice Thomas and Justice Alito, much more so with Justice Thomas, were accepting either free tuition or potentially a nice sale of Justice Thomas's house and a bunch of trips. Yet the Supreme Court doesn't have a code of ethics now. Do we think that if the court adopts a code of ethics, that the popularity of the Supreme Court will rise again? Does the court have an ethics crisis? And I'm going to open that to anyone who might want to weigh in on these questions.
I mean, my sense is that I don't believe that adopting an ethics kind of program is going to increase the legitimacy of the court. I just don't see that, but others could definitely disagree. Or if it does increase the legitimacy of the court, I think it does in very limited ways. I think that the people who are still very upset about many of the Supreme Court's decisions will continue to see the court as illegitimate. And the people who are pretty happy with the court's decisions will find the court to be legitimate. I think that doesn't mean that there should not be a code of ethics at the Supreme Court. And I do think that there are really good reasons to do so. But I wouldn't necessarily think it's about increasing the legitimacy of the court from kind of what we see, what our perceptions are. But perhaps it will, because we generally don't want our judges being bought off by private parties that may actually present some of their interests in front of the court.
So I agree with Latoya that ultimately people, when they are opposed to the Supreme Court, it's because they don't like its decisions. That's true of when liberals are opposed to the Supreme Court, it's true when conservatives are. And that's perfectly understandable because that's what most people really care about. So I don't think that having a code of ethics would be useful. You know, you could, I mean, for that, it could be a good idea in general. I should stress that a lot of these controversies, if there certainly are people who are saying that that the controversy has been misstated. So, for example, with regard to the purchase of Justice Thomas's house, I've certainly heard people say, and I haven't independently investigated, but I just sort of flagged that this was something that was not a particularly favorable purchase to Thomas. There was a similar argument, I want to say, about maybe Justice Barrett's home. Somebody said was bought by some lawyer. Pardon?
Justice Gorsuch.
Justice Gorsuch.
Well, there was a Gorsuch and a Barrett, yes.
Right. That was bought by somebody who was a lawyer, and but
Yes.
it turns out it was, that's because when you sell a house, some of the time people who can afford it happen to be lawyers at big firms. Likewise, for example, Justice Sotomayor, as I understand it, people have faulted her for, first of all, she got very large payments from her publisher for her book, which she should be entitled to do because, it sounds like the book sold a lot of copies, but apparently she didn't recuse herself of cases involving the publisher. It's an interesting question whether, though, that's something that's necessarily that bad. Again, it sounds like it was an arm's length business relationship. She did have an incoming royalty stream, but not a property interest. So often there are actually complicated questions as to any particular one of these items. I'm inclined to say it's probably a good idea to have some kind of ethics code, although some might be not very good, but ultimately I think Latoya is right that all of this public opinion about the Supreme Court turns on, and probably correctly, the court's decisions and not these occasional assertions.
Yeah, I don't think I completely agree, because I think in general, yes, the public cares a lot about the decisions. But I think the current ethics mess has broken through to a lot of apolitical voters who are not paying enough attention to the actual decisions of the court to know what's going on. The current situation, which I think is an absolute embarrassment, has produced all of these stories of, Justice Barrett going out and saying, we need an ethics code. Justice Kagan going out saying, we need an ethics code. And it starts to become obvious that the justices who are refusing to sign on to the plan to create the ethics code include Justice Thomas, who everybody now knows has received, enormous amounts of money in trips and fancy lodging and fancy clubs and spoken to big donors to Federalist Society groups and stuff. And so it starts to seem, I think, embarrassing in a way that I suspect has in fact nudged public opinion. But the real reason that the public opinion of the court is low is simply the Dobbs case, which you can track the public opinion of the court before and after. Many of us thought Bush v. Gore would lower people's opinion of the court. It didn't. I thought, that Shelby County, which eviscerated Section 5 of the Voting Rights Act, might reduce people's opinions of the court. No. Citizens United was another major conservative landmark opinion that resulted in a lot of campaign finance deregulation. It seems that, whatever 2% of people may have cared about it, but just no, none of this stuff broke through. Dobbs was different. It overturned Roe v. Wade, and a lot of people who were not paying attention to the rest of what the Supreme Court does did pay attention to that. And there's a clean break in the public opinion of the court dropping as a result of that sort of one exceptional opinion. And I think it will be somewhat difficult to recover. I mean, the opinion of the Supreme Court has had a partisan skew for obviously forever. I appreciate, I think, the analogy to the Warren Court for the current court is, generally quite apt. And the result of the Warren Court's decisions was that it was actually kind of regional. Public opinion of the Supreme Court in the North and the West and most of the country went up and was very high as a result of all the things that the Warren Court did, or some of them were the high profile ones, especially Brown versus Board of Education. Opinion of the court in the South, among white voters anyway, took an absolute nosedive, and there became a kind of politics of running against the Warren Court that became a central part of kind of conservative politics for many generations. Which was not unlike the previous round of FDR running against the conservative court, in the 30s. And so the question is, will there be a round in the future of liberals or progressives kind of in their politics running against this court? And I don't know the answer to that.
Well, we're almost out of time. And I want to talk about next term. And since we only have a few minutes, I'm just going to turn back to Eugene to tell us about gun rights, which is something that was not on the agenda of the court really last year, but is now in this Rahimi case. Can you just very briefly tell us what's at stake in that case and what we should be looking for?
Sure. So the Supreme Court has said that the Second Amendment secures an individual right to keep and bear arms. By the way, if you look at state constitutions, the overwhelming majority of state constitutions, there's not even any dispute. They obviously create an individual right to keep and bear arms. So then the question becomes, what are the exceptions from this right? And in particular, is there an exception for people who are adjudicated dangerous? Now, of course, one way of adjudicating someone dangerous is you lock them up. And then at that point, they don't have gun rights in prison. And maybe not even on probation, which is sort of viewed as just an extension of that. But what happens if somebody has, for example, a felony conviction? Or what if somebody has a violent misdemeanor conviction? Or what if somebody is subject to a domestic restraining order? And the Supreme Court said in its individual rights Second Amendment cases, well, of course, there are these historically recognized limitations with regard to people such as felons or the mentally ill. Now, interestingly, if you look at the history of disarming felons, it's actually relatively recent. It doesn't go back to the 1700s and 1800s. To be sure, there was more of a history of killing felons in the 1700s and 1800s. A lot more crimes carried the death penalty, although a lot of felonies didn't, at least in effect, and people could be locked up for a long time, but once they were released, historically, they hadn't been limited in their continued use of guns, at least until the early 1900s. Still, there are these decisions from the court that say, oh, felons are not protected. So the Rahimi case that's coming before the court asks, well, how does this apply to people who have not been convicted in a criminal case of a felony? Mind you, the felons unprotected may be nonviolent felons, but they may have been found to be possibly threatening violence or dangerous, but only in a civil case, often with a very abbreviated procedure, where a judge hears a request for a harassment restraining order and says, okay, fine. So no jury in that case, no proof beyond a reasonable doubt in that case, no right to a court-appointed lawyer in that case. So one question is, does this exception to the Second Amendment for felons extend also to people who are subject to these kinds of restraining orders? That's the precise issue at stake at Rahimi. The Fifth Circuit said no. There is the process involved in getting the restraining orders is just so much more abbreviated than for felons that it doesn't count. Judge Ho concurred, and he said, look, there are lots of tools for fighting domestic violence. They just are through the criminal justice process. So if you actually have the goods on someone and can lock them up, you should do that. But short of that, short of the standard criminal justice process, that's not enough. Interestingly, though, there are other things coming down the pike as well. For example, what about people who are nonviolent felons? Should the court's dictum or dictum statements about that be modified? Another issue that comes up is people who are users of unlawful drugs, which of course under federal law includes marijuana. So under federal law, anybody who occasionally uses marijuana in the many, many states where it's been decriminalized as a matter of state law is actually committing a federal felony. If they possess a gun. So those kinds of things are likely to be potentially at issue in the Rahimi case, which is why I think people are focusing on it very closely.
Can I add something to that?
Yes,
just really
please.
quickly? So I also teach family law, and I think it's really important to think about this case under family law as well, which is the idea that lots of times survivors of domestic violence actually don't have many criminal things that they can bring into court to have someone actually adjudicated under a criminal law. And that's often the reason these processes are very, abbreviated, right? It's because they usually are under very impressive time constraints where someone has actually gone about threatening someone, and therefore that's the need for the restraining order. And honestly, restraining orders are not easy to get, right? There is some amount of process that goes in that, but just thinking about it from a family law perspective too, and the types of protections that this will have for survivors and victims of domestic violence.
But just to be clear, if indeed there's a threat, and if it can be proven in criminal court beyond a reasonable doubt, that's a crime. That's a crime. People are convicted of criminal threats. So what you're talking about is a situation where, for a variety of reasons, there's just no criminal case brought, but sufficient evidence to think this person is really dangerous. So that's the question. And by the way, it's something that ties in a lot of other situations, which is what kinds of procedures should be viewed as adequate in order to restrict people's constitutional rights.
Well, it sounds like we'll have a lot to talk about next year. Before I thank the panelists, I want to thank Harley Ham and the team here at UCLA. Let's just give them a round of applause for all of their work. And join me in thanking the Lebow family for sponsoring this event and our excellent speakers today. We'll see you next year. Thank you so much.